Hi everyone, my name is Zavala, and today I'm going to be talking about guardianship. So to start, we're going to talk about what is guardianship and why is it important. So Melton et al. Explains that guardianship is a legal mechanism where the state delegates authority over an individual's person or estate to another party. Guardianship is important because it can protect those individuals who are unable to make their own decisions. Those who cannot make their own decisions may be due to a number of factors such as old age, a disability, or even a mental incapacity. In most cases, the court ensures that there is someone who is legally authorized to make important decisions regarding the ward's treatment and financial decisions. So next we have reasons for guardianship. So when determining if an individual needs a guardian of some sort, it needs to be determined if they are lacking specific or general capacities. If one is actually incompetent, it means that they are de facto incompetent, and when one is found incompetent by the law, it means they are incompetent de jure. When defining what an incompetent individual is, there is more to consider than just the individual having a mental disability. The Uniform Probate Code defined an incapacitated person as someone who has a weakened ability to function due to a mental illness, mental deficit, physical illness or disability, advanced age, chronic use of drugs, chronic intoxication, or any other reason that may cause the lack of understanding for the individual to make a reasonable decision concerning themselves. So all of these factors can lead to someone being unable to understand the severity of certain decisions being made. In many states, an evaluation of the individual may be required to determine if a guardian is needed. So when it comes to older minors, not much thought is given to whether they are incompetent or not because they legally cannot act on their own behalf. And because of this, courts are rarely deciding on their need for a guardian. Although most can make reasonable decisions on their own, they're usually assumed incompetent until they can argue against this assumption. So for example, if we're presented with a 16-year-old child, they may be able to make decisions on their own and can understand the basic ways of living. However, the court may not see that for themselves and will appoint a guardian to ensure the right decisions are being made for that child's well-being. So next we have this video. Um, it was published by Bundy Law in 2024. It explains the ins and outs of guardianship. They continue to explain the circumstances that define when an adult is in need of a guardian, which could be due to the inability to make decisions. They also talk about the overwhelming feeling individuals may experience when they're going through this whole process because it can be a lot. And some things that I feel are important to take away from this video are those legal thresholds, the documentation process, and the roles and responsibilities of the guardian. And then on the next slide, we have this QR code for that video. If you want to take a look at it and watch the whole thing, feel free. So next we're going to talk about these clinical evaluations. So during these evaluations, there are several points that the evaluator needs to consider when they're conducting one. So they need to consider the loss of decisional autonomy associated with guardianship. They have to focus the assessment on the functions the individual can perform. They have to see if the individual's weaknesses can be helped with the assistance of someone else. And it's important for them to stay attuned to new strategies for performing guardianship evaluations. So during the evaluation, Moy explains that evaluators should use the testing, observation, and third informant report to help evaluate the cognition and behavior of the individual. There are two types of instruments that Melton et al. Describes as being the most studied. The first is the direct assessment of functional status, where the individual is required to perform activities and assign points to how well they completed each activity. The second instrument is the assessment of capacity for everyday decision making. And this just helps the evaluator assess the individual's capacity to make a decision with regard to solving their own functional problems. For this instrument, an interview is given to the individual's caregivers about the ward's issues solving everyday problems. So basically, if they struggle with certain areas in their life where they can't solve, let's say they can't solve how to deposit a check or they can't figure out how to put their dishes away. They look at things like that to see if, okay, yes, we need to send a guardian in to help them with their everyday lives. Next, we have guardianship types. Luckily, there's only two. So one is general and the other is specific. So general is also known as plenary, and this guardianship gives the guardian total control over the ward's person, estate, or sometimes both. So they can make decisions about everything and anything on the ward's behalf. They are given full responsibility of treatment decisions, financial decisions, anything that has to do with the ward's property, they have control over those decisions. However, a specific guardianship is also known as limited. And this means that the guardian is restricted to the types of decisions that can be made for the ward. So, an example of an individual under a limited guardianship is when the guardian is only allowed to spend up to $100 a week and cannot make a larger financial decision for the ward under any circumstance. So, although limited guardianships do allow for the ward to have more freedom than the general guardianships, they're rarely used. Next, we have who is the guardian. So, when deciding who is to be the ward's guardian, they can range anywhere from family members to government agencies, social workers, lawyers, and even sheriffs. So for every guardian that's presented, there's always going to be ups and downs. So there's a risk that those guardians who are not family members may not be taking, excuse me, those that are not family members may not take being a guardian seriously enough to ensure fair and safe decision making. With that, there is the issue with the costs of a court-appointed guardian. Over time, the costs can get very expensive. And then we have family members who we believe are going to be the ideal guardians, but these also present issues because of conflicts of interest when it comes to different types of decisions that have to be made. So, majority of those decisions that can cause issues relate to the ward's money and how it may be being spent. Other family members of the ward may find the use of the money inappropriate. The choice of the guardian is not always going to be what is preferred by the ward. It comes to be a matter of policy or law. And most times, mental health professionals are not able to provide insight, but they can only when conflicts are observable to them. Next, we have guardianship duties. So there are two models that help decide, I'm sorry, that help guide the guardian's decision making. So the first one is the objective test, which is also known as the best interest model, where the type of action is determined that can serve the ward's best interests. And the second model was determined in a case that took place in Massachusetts and New Jersey, where the guardian is to make a subjective, substituted judgment. Their judgment is to choose or act as they think the ward would have if the ward were competent. So it's basically how it was said. It's like they're putting themselves in the ward's shoes for the subjective substituted judgment and thinking, how would the ward make this decision for themselves? So in the court case, Cruzan versus the Missouri Department of Health, they determined that the latter standard is what should be required when the decision of terminating the life of the ward who has suffered an accident and is left in a vegetative state is in question. So this court case stated that they prefer to use the subjective substituted judgment when it comes to a matter of life or death. So what would the ward do if they were left in a vegetative state? So we do see more of the best interest model used in situations like child abuse and mental health treatments, only because we're trying to figure out what's going to be in the best interest of those that need mental health treatment, those who are in an abusive situation. What is the best decision to be made for them? And so, as adults, when the decision involves treatments of the ward, the treatment type will be determined based on what is in the ward's best interests. Next, we have advanced directives. So Melton et al. Describe advanced directives as instructions from a competent individual that direct certain actions if the individual is no longer able to make decisions about themselves. They are set to protect the individual's autonomy by ensuring that the proper care is given to those who do not have the capacity to make decisions. And they can come in different forms, such as a living will, durable power of attorney, and a formal mechanism. There are also psychiatric advanced directives, and they allow the individual with a mental illness to direct in advance the type of mental health treatment they would or would not like in the event of incapacity. So next we have our conclusion. So guardianship is a very complex thing to deal with when you're determining who's the guardian, what decisions can they make, what can be done to help the ward. Um, and even though they're challenging, they're always guided by the idea of supporting the ward in living the highest possible quality of daily life. So to finish up, we have this discussion question. It's why do you think limited guardianships are rarely used if they offer the ward more freedom? And what are some pros and cons to a limited guardianship? And these are my references. Thank you all.